If your disability claim has been denied by VA and you're appealing to the Board of Veterans' Appeals, you must choose between 3 dockets. One of the most popular routes is to request a hearing. Today we're going to talk about why that is a less ideal option than it might have been in the past. I'm Brad Hennings, a partner at Chisholm Chisholm Kilpatrick. Before joining the firm, I served as a veterans law judge at the board, so I've sat on the other side of these hearings. First, let me be clear. A board hearing is your right. Federal law guarantees you a hearing if you ask for one in 38 U.S.C. section 7107. That hasn't changed, and no one can take it from you. For some veterans, a day before a judge really matters, and that's a perfectly valid reason to request one. But a hearing is not automatically the best choice. It carries trade-offs that didn't exist even a few years ago. Under the old system, requesting a hearing usually made sense. The same judge who held your hearing decided your case, sitting in the room, hearing your story, and ruling on what they saw. Today, that's no longer true. In a case called Francis versus McDonough, the courts confirmed that under the current appeals law, or the AMA, the judge who holds your hearing does not have to be the judge who decides it. You may tell your story to one judge at the hearing, while a different judge who is never in the room reads the transcript and makes the call. The biggest advantage of a hearing, that face-to-face moment with your decision maker, is often gone. Then there's the issue of time. When you appeal to the board, you pick one of 3 dockets. Direct review is the fastest, with a target of about 1 year. The hearing docket is the slowest, with a target of 2 years, and in practice, many hearing cases take far longer, up to 5 to 6 years. A well-prepared case on a faster docket can be decided in under a year. And finally, the unfortunate truth is that a hearing might not make a difference. Among the cases that actually reach a decision, hearings produce comparable results to other dockets. When you correct for factors like representation, average case strength, and withdrawal rates, the data suggests that you're getting the same outcomes with months or years more waiting. I'm not telling you to never request a hearing. Sometimes it can be the right move. A hearing may add real value when your credibility is the central issue and your testimony is the only way to resolve it, or the way the disability affects your daily life isn't in the records and you really need to describe it in person. Or you're the only person who can speak to a key fact in your case, most often because you were the sole witness. In those situations, your voice may do work that no document can. But in most cases, a hearing only repeats what could have been written down, and it can add risk. An offhand comment, an inconsistency with an earlier statement, a remark that sounds worse than your records. All of that goes on the record, and VA can use it to deny the claim. So when it's time to choose your appeal track, here's something to consider. Don't request a hearing out of habit, and don't assume more process means a better result. What does a hearing add to your case that a strong written brief cannot? If there's a clear answer in support of a hearing, request it. If there isn't, the faster path may serve you better. If you aren't sure, think about discussing with a VA-accredited law firm or representative. If you want to read an in-depth analysis of the data and current state of law surrounding hearings, look for my article at cck-law.com, linked in the description. Thanks for watching.